Thank you, everybody, for coming today for our employment law update. Doing it in conjunction with Greenwell Gleeson, and I think Rob's going to get up and say a few words with a bit of a update on the recruitment market and the employment market generally at the end of this discussion. We decided that we were going to try and do something different. You might have seen it online. We've been doing a podcast for the last year now. It's on YouTube. If you search for Ansons Law, you should find it. Please like and subscribe. We're trying to boost the numbers. TikTok account as well, which I was delighted to see. One of the videos had got 50,000 views the other week, and then when you dive into the statistics, that the average length of the view was 0.5 seconds. It was slightly less impressive. That's not what I've been telling everyone. And also, listen, guys, really grateful for your coming out, particularly passing the initiative test of us putting the wrong postcode on the reminder email. But I guess enough of you passed that test, so you're here. Thank you for coming, and clearly you're obviously a very intelligent person if you've been able to work out that we got the wrong postcode, but there you go. Also, I think I'm normally these days the one doing the Q rather than the A part of this, and this sounds like some sort of like eve of World Cup football injury, but Jason, our head of employment law, has got an ruptured Achilles over the weekend, which not quite sure why that means he can't sit on a chair and discuss employment law, but he definitely can't drive and get about. So I've been substituted in I was trying to think of the appropriate football analogy.
You can't ask me about football.
No, I'm not going to. Well, so did sort of Lothar Matthäus come back to Germany in the mid-2000s? It's probably, I think, of age profile, I suspect I'm probably more like Roger Miller in the 1990 World Cup, but that's for men and women, of course, of a certain age. So yeah, getting those references in. We are here to talk about, in effect, the focus of today is on the Employment Rights Bill, which is quickly going to become the Employment Rights Act. It's ping-ponged. It was last in the House of Lords last week, and it's been sent back to the House of Commons today. And we're going to, first of all, discuss probably the biggest lead punch there, which is the change to unfair dismissal. Before my colleague Victoria Ramshaw is going to ask me a little bit about that before we get on to some of the other changes that are being introduced. So let's see how we get on.
Yeah. So, well, first of all, what is actually the biggest change, and why is it?
Didn't you just listen to what I said? Yes. The unfair dismissal bit was there. Well,
But what's the change?
No. So I'm teasing. So the big change is introduction of day one unfair dismissal rights. So currently, you had to be employed for 2 years before you could bring an unfair dismissal claim. Unfair dismissal claim is one of the larger number of claims. I think it's 22% of all employment tribunal claims are unfair dismissal, and up until when this law is introduced, you had to be employed for 2 full years before you could bring a claim. It was the same, actually. It's mirrored in terms of your entitlement to a statutory redundancy payment as well. And what is going to happen when this comes into force, and we're being told it's not going to come into force until either April or October of 2027, so there should be a decent lead-in period. But at that point, you could start a job on a Monday and, bring a claim on the Monday as well. I was going to say, like, chilling on Sunday and try and turn it into the lyrics of a Craig David song, but you could do it the same day. On the first day that you were there, if you were dismissed or perhaps even constructively dismissed and you resigned, you could bring a claim for unfair dismissal on the first day. So that's a real radical difference, and certainly the biggest change to unfair dismissal law since the 1970s when it was introduced, I would say.
Yeah, absolutely. But just going back a bit, what actually is unfair dismissal?
So this is the bit where I do look at my notes, but it's defined in the negative in some respects in terms of what is a fair dismissal. You've got the right to not be unfairly dismissed. So in terms of how it's defined, there has to be it's a two-stage test, there has to be a fair reason for the dismissal. Fair reason being everything that you would expect, which is disciplinary reasons, misconduct effectively, capability, which is poor performance, redundancy, the no longer having the need for a certain work to be carried out, sometimes in a certain place. And then there's a catch-all category called SOSA, which is some other substantive reason. So first of all, there's got to be, the dismissal has to fall into one of those fair reasons. And then secondly, it has to be, in effect, both substantially and procedurally reasonable. And of course, the devil is in the detail of sort of what that means really in terms of what is reasonable and what is not reasonable. And in effect, I suspect what really it is trying to do, and we'll come on to that in a little bit later on, but it's trying to impose when an employee is losing their job, that the employer conducts a fair process.
Yeah, absolutely. And but just on that, there's also some automatic unfair dismissal categories as well. So as well as having the general reasons, some of things are actually automatically unfair.
Yeah, there are certain automatic unfair dismissals. If you were to dismiss somebody because they were pregnant, that would automatically be unfair. No need for a qualifying period. You know, do not pass go, do not collect £200, go straight to the employment tribunal. You know, and there are other categories of automatically unfair dismissal if you were asserting a statutory right, such as trying to enforce your rights around the national minimum wage or around the working time regulations. If you were dismissed for that, proving that is the reason you were dismissed is another sort of thing that might be difficult. But if a tribunal was to accept that you had been dismissed for enforcing a statutory right, that would be an automatically unfair dismissal.
Yeah. And I know you like to go into the history of these sorts of types of claims and go back into a bit of the case law. So how was unfair dismissal actually introduced originally?
We're going back to 1971. Edward Heath government introduced it, and it was introduced into what were industrial tribunals, which were created at the time, and it was clearly a sort of in an era where there was a lot of sort of trade union and industrial strife, and it was partially a measure to give something to the employers, give something to the workers, a right that I think the trade unions were at the time were pushing for. And yeah, that was when it was introduced. In terms of its history, I'll discuss the case law in a second, but it's gone through different phases whereby, depending on which government's in power, the qualifying period has been 1 year, and then a different government's got in and extended it to 2 years. During my career from 1999, the 2 year, it was reduced from 2 years to 1 year by Tony Blair's government. And they, partly through that government's tenure, they introduced, and it was a disaster really, the statutory, I don't know if people remember, the compulsory disciplinary procedures that were introduced, which just led to there being loads of satellite litigation about like whether you'd complied with, because it was about form over substance. So if you hadn't put the right form of wording in your dismissal letter, you were again, it almost was tantamount to automatically unfairly dismissing people. That didn't last long. I think it lasted only a couple of years. And then when the coalition government got in 2010, they introduced, they pushed it back up to 2 years. And actually for a short period, and again, this didn't really work, they introduced fees. So employees had to pay a fee to bring a claim. That completely reduced the number of claims, not quite down to nil, but it was something like 80 or 90%. And it was felt that whilst there are, and we'll come on to that, quite a few vexatious claims from employees, that clearly people weren't saying that 90% of the claims were fake or vexatious. So that was, and it found, I think, to be indirectly discriminatory. Might be something we touch on. And that was abolished as well. But beyond that sort of tumultuous period, sort of between 2007 and 2012, this is certainly the biggest change since then. Really.
Yeah, and out of that, what you say, it sounds like you're saying is the only real changes have been the qualifying periods just moving a bit.
Well, no, I mean, the stuff that they did around fees and the stuff that was done around the compulsory statutory disciplinary and grievance procedures were significant. I mean, but they were short-lived. I guess, if anything, what I would say is the case law, where the judges and we know we've got a system of precedent in this country, and tribunal cases can be appealed up and have been into the House of Lords, but we've also got an employment appeals tribunal. The case law, actually, if you look at it and Google, dare I say, even ChatGPT, not that that's what I did yesterday. I wish I'd done that for the postcode. There actually, arguably, haven't been any significant unfair dismissal cases for the last 10 years. I mean, it's a significant case if you're bringing it. But, and I think that the concern here is that you get into sort of fiddly statutory regulations and instruments. I know that the employment, the sector of the economy that is employment agencies have had lots of that really, really fiddly regulation over the last 10 years. Lots of the time, it almost has the opposite impact of, what you were trying to achieve. I do think that the case law and unfair dismissal as a right is something that is actually far more employer friendly than people realise. I'm not saying dealing with a claim is a nightmare, and I get that. But in terms of the law here, right the way back from the 70s, we've got the first landmark case, which is the British Home Stores and Birchall case. And the tribunals are saying, look, we want you to follow a fair process. We want you to have a go at following a fair process. We are not expecting perfection here. And one of the early cases, the Iceland frozen foods case, we get to this concept of band of reasonable responses, that a tribunal isn't just going to substitute its view as to whether a disciplinary process has been fair or a redundancy process is correct. They're not just going to say what we would have done. They're going to say, does what this employer has done, given the information that was available to him or her or it, I guess if it's a company, has that employer, its decision-making fallen within the band of reasonable responses that an employer could have reached that decision. And that will sometimes mean, I was once on a seminar, and a older solicitor who'd probably be younger than me now was given a story in his workplace whereby he dismissed an employee who he felt was smoking a cannabis joint in the workplace. It was subsequently and definitively proved that the employer definitely wasn't the person. Somebody else eventually came forward and admitted it, and it was conclusive that it wasn't that employer. It wasn't that employee. But the process had been fair. They'd had a disciplinary. There'd been an investigation. They'd had a disciplinary. They'd given the reasons for the employee. They'd given him the right of appeal. And when that employee brought their claim, the tribunal said, well, look, we accept that he didn't do it, but this was a fair process, and that it was, it was not an outrageous decision. It did fall within the band of reasonable responses. So I do think that sometimes there is a bit of a myth around unfair dismissal, that it's about almost trying to get an employment law judge to say what they would have done. Do they agree with your decision? But it's not really. And in some respects, probably calling it unfair procedure dismissal would be a better, unfair process is probably a better way of looking at it than actually just unfair dismissal, because actually ultimately they're not saying, do we think this is fair or not? They're saying, has there been a process, and could an employer have reached the same conclusion as this employer has?
Yeah, so it's what the employer thinks about the reasons for the dismissal, rather than that's less important than the process itself, as long as they believed that was the case and they followed a process based on the information that they've got available.
Yeah, I mean, that doesn't mean that you can, that you can reach an outrageous decision that is so extreme on the evidence that, that there's O.J. Simpson type sort of finding or whatever that just strikes everyone as being, incredible. But provided, again, to repeat myself a little bit, provided that the tribunal can see that the process had been implemented and an employer could have got there, typically that would be determined to be a fair dismissal.
So on that basis then, what's the real significance of this change then for employers?
Well, we'll come on to some of the practical bits in a second. I think there's an argument that says if you are dismissing somebody now, regardless of their length of service, you should be following a process, because we've got all of this law. You alluded to it earlier about automatically unfair dismissal. Most of the categories of automatically unfair dismissal, which includes whistleblowing, which includes discrimination claims, which includes claims relating to enforcement of a statutory right, all of those claims allow you to bring an unfair dismissal claim on day one. As it stands, if you were to suffer that type of discrimination on day one, you could resign, claim constructive unfair dismissal and sex discrimination, and bring that claim on day one. What that has meant practically for a number of years, and that expansion of the sort of regime of discrimination law, but also automatically unfair dismissal without the qualifying period, has grown over the last sort of 10 to 15 years. And that has meant that every time we advise any employer going through a process, we will always say to that employee, it can be light touch, but we want there to be some kind of process. What that process involves when it's light touch is probably that you're inviting them to a meeting so that they know that what they're getting into when they step into that meeting, that it's possible that they could be dismissed following the meeting, that you would take notes of what was said, that you would, after the meeting, confirm in writing, which most employers would do anyway, the fact that they have been dismissed and the reasons for that dismissal. You would also give them the right of appeal. And the reason that you're doing that is that if they were to say, well, it was discriminatory, well, you're trying to draw that out, because if they're saying you've done this because I'm asserting a statutory right or I was whistleblowing, well, you would then think they might say that in the meeting, or certainly they would assert that in the appeal. And then if they do assert it, you can deal with that. And if you have dealt with it as an employer, if you've confronted and properly explained, as I said earlier, and it's documented, very hard for that employee to bring a successful claim in circumstances where, in black and white, in writing, the issue has been set out and the reason for the dismissal has been flushed out, and it isn't one of those reasons.
So practically, it's not, employers should continue to follow those processes. They already have.
Yeah, no, I would say that employers should always dismissing anyone, even if it's light touch, even if it's quite quick, and even if sometimes it's rough and ready, there should be some kind of process that you implement when you're terminating an employee's position for anything really. And indeed, if it's at the end of a probationary period, hold that meeting and explain that, it's scheduled, it should be in the diary, it's scheduled, and you would explain, unfortunately, it's not working out. And if that's the decision that you would, terminate their employment at that stage, or indeed push forward the probationary period, perhaps extend it by another 6 months. And if, again, they've not convinced you by the end of that period, perhaps at that point is when the termination occurs.
So we've discussed the significance for employers. Is it going to be quite significant for the actual tribunals?
Well, that's loads of the concern, really. I mean, I would say that tribunal system, like a lot of the court systems and prison service, everything that's responsible by the Justice Department is absolutely creaking. So we've got currently got 500,000 open cases. Of which I think a lot of those are sort of multi-party cases, which some of those are equal pay claims, which is what sort of bankrupted Birmingham City Council. But in terms of individual cases, you've got 5,000 open cases. And I mean, you do more of this than me, right? I mean, you said to me the other day, how long, some of you've got a case that's going on for?
So in my experience, it's been 12 to 18 months to get to a final hearing. But I've spoken to other employment solicitors and they're seeing cases being listed for 3 years down the line. So that's 3 years of the employer potentially incurring legal fees, 3 years of the employee being just not knowing what the outcome's going.
Yeah, I mean, there's a concept in law, right, that justice delayed is justice denied. It doesn't do anyone any favours. And I definitely, people in this room will remember in tribunal claims being issued and probably having the hearing, it all being done within sort of 6 months. I mean, in some respects, us as lawyers, when you're dealing with the cases, it increased the workload. But, I know that one of my colleagues has got a case that after 2 years has only been sort of listed for directions, haven't got a trial date yet. And I think that's only going to get worse. And especially with this, I think there's going to be an increase, especially as people learn. When it is introduced again, it's not until 2027, but when it becomes sort of common knowledge that you can bring that claim early, I think that we'll get an abundance of claims, and I think it will drive the tribunal system to a halt. You were saying to me the other day there's some signs of this already, insofar as there's compulsory conciliation and of ACAS, the change in the.
So something's been snuck into Parliament recently to extend the early conciliation period. So prior to issuing an employment tribunal claim, an employee has to contact ACAS. They have to try and settle a claim with their employer. Currently, the period that they can do that for is up to 6 weeks. But what was introduced last week, it was secondary legislation that's going to extend that from the 1st of December this year to 12 weeks.
And by the way, that's not done for any other reason than that ACAS is just absolutely inundated with claims and they just aren't able to get to them within 6 weeks.
Yeah.
So, that's where that's coming from. I mean, I'm actually quite pro ACAS. I've had a couple of good experiences with them recently. And so that part of the system, I would say, if you can get a good ACAS conciliator, they basically do shuttle diplomacy. They'll ring the employer, ring the employee, try and make contact and see if they can come up with some sort of settlement. But clearly, if they're having to have that period extended by up to 12 weeks, that's not a good sign, and that's just showing that the system's really creaking.
But also, the parties aren't required to negotiate settlements for up to that period. So there's a 12-week window now, or will be from the 1st of December, where you don't know whether the claim's going to have to be issued.
There's loads of uncertainty. And if, as we are also hearing, that the limitation period be extended by up to 6 months, I was having a discussion with Rob earlier that uncertainty, you have dismissed someone and you don't even know if you're going to get a claim for 6 months, and then one day you open the mail and there's an employment tribunal letter there. I mean, I think that's not good either.
Yeah, so it could be up to 10 months after they've actually been dismissed. Now with the ACAS extended period, and you get a month less a day after the conciliation period's ended. So you're looking at nearly a year, so 10 months after dismissing someone before you actually get one through the door.
Getting very negative, but yeah, no, it's not good.
Yeah. So speaking of implementation, then, how far along is the bill now? What can we expect? And
so it might even be completely concluded this year. That's their aim, and they are saying 2027. Is when it will be implemented. There'll be further consultation, and that's actually where some of this stuff, and perhaps might be a question as to why we're having this seminar now. But I'll tell you why in a second. But I think that there is meant to be a sort of proper consultation that's to follow this as to what it's all going to be set out in secondary legislation, in regulation and directives. So, and ACAS guidance, I suspect. So that is meant to be a lead-in period for the employers and the employees. But there is, of course, what that also means is quite a bit of uncertainty as to what it eventually is going to look like.
Yeah. The other thing, I think I saw that the limitation periods are actually going to be implemented as soon as the Act is.
That's going to do that straight away to 6 months.
Royal assent. Yeah. So some of the changes
that could happen immediately.
Yeah.
Right. Yeah.
So, are there any ways that we can get around this? Are there any things that we could do with maybe probation periods? I would say that probably the one thing that I would be doing as an employer is, I think that obviously the most significant impact is early claims when you decide as an employer that it's just not working out with somebody. And a lot of the time you can tell straight away. And those employees will now, if you haven't followed some kind of process, be able to bring a claim on day one. I think I would try and get into the habit of always implementing some kind of process, even if it's light touch, for any dismissal within the first 2 years. And I think that I would properly be trying to implement a system of both a probationary period properly. And I think probably a lot of us are guilty of, with probationary periods, if it's going well, we just don't really do anything about it. And also, despite us all probably having policies that say we're doing performance reviews, a lot of the time they're the sort of thing that we never get round to implementing. And I get it. Most of our clients are SME businesses. Ansons is an SME business. When he's doing the performance review or having formal meetings on some of this stuff, when is it ever that important to do? But I do think that it is, and I think that if you can get into the habit and change that sort of culture so that we do document things and the discussions that we are having with our employees, particularly around performance management, particularly at the end of a probationary period, that we make sure that we put that in the diary sort of 5 months in, or so that you can make that decision before the 6 months. I think that if we do start to do that, I think it'll make it a lot easier, and it'll be a lot less of a shock when the legislation does get implemented. And of course, if there is a claim, at least you've got the documents to.
Well, I just think you've got the documents to respond, and you're virtually making it impossible for somebody to bring in a successful claim. We do think that in relation to probationary periods, there's going to be some guidance, and I mean there might be like a statutory probationary period and a statutory fair dismissal, which is non-passing of a probationary period. That fills me with a bit of fear, really, because that reminds me of the compulsory disciplinary and grievance procedures that were introduced and were a complete and utter failure. But we shall see.
Yeah, a lot of this is going to be secondary legislation, so we can't even speculate at the moment as to what that could be. But
we can. That's what we're doing today.
Yeah. Well,
that's what we are going to do.
Yeah. So what's the main level of risk then? Just really, really.
Yeah. No. I mean, I think that ultimately here, I think I'd like to give employers confidence. And listen, if you're the type of employer who's coming to an employment seminar, it's something that you're interested in, and actually, chunks of this probably shouldn't affect you too much, right? Now, I know that we're gonna get vexatious claims, and maybe I'll come on to that in a second. But on one level, there is an element that most good employers are having probationary reviews, are having performance reviews, are implementing proper redundancy procedures. And actually, it probably, at the moment, the sort of cowboys who just dismiss and fire at will within that first 2-year period and who get away with it. On one level, there's a framing of this that says, well, this will, this will mean that actually they are putting themselves significantly at risk now. And if you're an employer who adopts proper processes, treats its employers fairly, you're not going to be impacted by this, but they are, and sort of that maybe levels the playing field a little bit. I am worried though, and I think everyone will be, that it'll just be so many more claims, and we all have been stuck between that rock and a hard place of you don't get your costs back if you win an employment tribunal claim, and you don't have to pay a fee if you're an employee. So sometimes, however, you will get advice from lawyers, from HR advisors, that you are better to settle the claim, and that always sticks in the craw when you haven't done anything wrong, and particularly in an owner-managed business where it does feel quite personal. I wish what there was a proper sort of system of case management. Perhaps AI could be used to help with this, whereby the absolute nonsense claims where there's no case to answer could be filtered out early. Tribunals have had that power for decades, but perhaps because of maybe partly Human Rights Act, but and right to a fair trial, they have never properly thrown out rubbish cases. And I think that if they did proactively throw out the vexatious and just silly claims early, they wouldn't just be helping the system and generally, it actually is kind to the employees as well, because an employee who's got a rubbish claim, taking that all the way, all the stress and aggravation over 2 or 3 years to lose, that's personally devastating to them as well. And what we haven't seen ever is sort of proper proactive case management whereby either claims are being thrown out, or perhaps the employee, if they do want to pursue a claim with poor prospects, they do have to pay some money into the system that can be used to compensate the employer. That's not going to happen, by the way, but that's what I would like to.
Yeah, I think the closest that I've seen has been preliminary hearings listed, and all they end up being is a long hearing where the employee gets a chance to explain their case, and sometimes the tribunal ends up almost perfecting it for them and trying to pull out the key points of their case for them, which is a lengthy exercise, and still doesn't mean that they're going to be successful in the end.
No, I don't. Again, you sometimes have to be cruel to be kind, and I think that if we could have a system that properly filtered out the poor claims, I think that most employers would accept that when you have got processes or practices that are blatantly unfair and there's good evidence to support that it was an unfair dismissal, those claims need to be heard. And people, I don't think, generally speaking, from employers that there is a hostility to the right of unfair dismissal. I think it's pretty well established now. It's been here for 50 years. The law, counterintuitively, is in some respects in the employer's favour, as we've said. It's not about whether the tribunal would have made that decision. It's about whether a reasonable employer within the band of reasonable responses could have made that decision. Yeah, so I just wanted to say, in terms of concluding the bit on unfair dismissal, my takeaway would be to try and lawyers are always going to say this in employment law seminars, but have a look at your processes and procedures, particularly around probationary periods, and making sure that that is in your contracts, that you've got a process that you follow, and not just that it's written down, that you actually do follow that. And that would be the one thing I would be doing.
And obviously, we're always here to help if anybody needs it.
That's good salesmanship there from you, Victoria. We are, and we have got. We'll come on to it. We have got our own sort of retainer scheme whereby we would always review your policies and procedures for you. And actually, part of that is, if you are dismissing an employee, we can give us a call very quickly. We can just make sure that you are, I've said light touch, but like complying with those light touch, processes to avoid somebody bringing a claim later on. And ultimately, I do know that a number of my clients, some of the ones sitting in this room, that they, having spoken to us a few times with this, they do still ring up just to seek a bit of reassurance. But for the most part, they sort of know the drill. And I know this person's only been here for X, but that like put in place the letter, the meeting, the notes, the decision letter, and with the right to appeal. And I think if you do that, in terms of having a large number of successful claims against you, I think you'll be able to virtually eliminate any successful claims against you. So it's now my bit to do the Q bit of this in relation to some of the other changes, which will... Yeah. Cheers, Carl. So sexual harassment is this has happened already, actually. This isn't the Employment Right Bill, is it? Or
so it happened last year as well.
Yeah.
But they're actually expanding on that. So last year, the duty was introduced to take reasonable steps to prevent sexual harassment, and the Employment Rights Bill actually expands that to all reasonable steps.
So the difference being was that previously you had a defence as an employer. If you got the sort of
policies, procedures, you could show that maybe you had a training.
But you could say this was just some perv, right? Yeah. We did all we could do, but this man, and it would typically be a man, is a rogue, and we've got a defence, but that's not enough anymore.
No. So last year they introduced the first positive obligation on employers to actually take steps to prevent it.
Right.
So we've previously discussed things like risk assessment, so you can identify where in the business there's a particular risk of this occurring. But now it's not going to be enough to just take reasonable steps. You're going to have to take all reasonable steps, and we don't know what those steps are. The duty is going to be introduced, they're saying October next year. Currently, but the secondary legislation that's going to tell people what these steps are that they have to take won't be introduced until 2027.
This is the death of the Christmas party, right? But work events with drinks, currently in terms of reasonable steps, you could have a Christmas party with drinks, but it might not be the unlimited bar. There might be drink tokens. There might be certain steps that you're taking to sort of reduce the risk, number of people in the room who aren't drinking, who can chaperone, etc., etc. That you take steps to be careful, right?
Yeah. And as lawyers, we do attend some events that sometimes it's an evening event, you go out for a drink. It's making sure that you've got some sort of policy in place so that people know what to do if they did experience anything, and what they can do to prevent that.
Okay, so we've got some the other changes beyond harassment and discrimination. What are some of those that we've got coming in place in the actual rights bill itself? So
we've also got changes to 0-hour worker contracts.
Right.
So this is dealing with workers rather.
That is horrendous. That's my phone. Sorry, 0 hour. I'm glad I'm not on a 0-hour contract, or I'll be getting terminated.
Yeah.
And enforcing my unfair dismissal rights that don't exist yet.
Yeah. So this is applying to workers rather than employees. Workers on low hours will have a right to guaranteed hours based on the minimum hours that they work.
Right.
Again, we're not actually sure what that's going to look like yet.
Because the last government put some legislation down around this, didn't they?
So the last government did. They introduced a right to predictable working hours, but before that was actually introduced, it was repealed by the Labour government.
Right.
Because they were going to replace it with this.
Yeah.
But again, this isn't going to come in until next year. But what it means is employers are going to have to provide a contract guaranteeing a minimum number of hours for those low hours workers, and potentially it could also apply to agency workers. So if an agency worker or a worker is working more than the hours that are actually set out in their contract, the employer is going to have to and there's going to be legislation on what those low hours have to be. There's going to be a minimum. The employer is going to have to do an average over, we think it's going to be 12 weeks. Again, it's subject to secondary legislation, and provide them with a contract based on the minimum average hours worked. Currently, there's nothing in place to stop that occurring for seasonal workers. So presumably that's going to be part of the consultations, because if you have staff working additional hours
or whatever, then or you're going to be doing more stuff in the summer, then it'll be an implementation nightmare. It strikes me that this is almost like the abolition of the worker status. They're trying to make workers get as many of the employee rights as possible.
Yeah, they've been quite clear about that. They're trying to make sure that as many people are caught by employment rights as possible, but by guaranteeing minimum hours, you are then essentially taking on an employee nearly, depending on how those hours are worked, whether they can be refused, whether the worker is entitled to just say, no, I don't want to work those hours.
The devil's going to be in the detail, but I think that, again, probably somebody being kept on 0-hour contracts for months on end, but working the same hours every week, and just occasionally it being used by the employer to, cancel a shift or cancel a shift for a week because something's happened. I think there should be greater protection around that. But if it gets too fiddly, as we've seen in the past, 0-hour contracts are attractive to a certain, section of the economy. Certain people want the ability to take shifts for 5-6 weeks and then go away for 5 or 6 weeks. Know that that's one of the ways that sort of people who wanted to get back into the labour market in the 60s and 70s, which the government's meant to be encouraging, they want to be able to take the Sainsbury's shifts, but then equally spend the summer, in Spain or whatever, and then not lose the job because of that. So, again, it's another watch this space,
isn't it? We're going to have
it?
to see how it works, but also they're going to be helping with workers who do have their shifts cancelled. So they're going to introduce some compensation for late cancellation. They still need to define what late cancellation is, but it means that a worker that believes that they're going to earn money on that shift, at least they're going to get some compensation for a last minute cancellation of that.
And I think, again, in terms of what employers who are listening to this, we don't know what the legislation's going to say. I think you probably have got a direction of travel which is going to make the use of 0-hour contracts more difficult, and probably it's reviewing your workforce and to see for the employees who you have got on 0-hour contracts, is that the suitable vehicle? For some of them it will be, definitely, and that's the two-way street. Some of your employees who've been doing the same hours for months now, it might well be time to properly integrate them into the workforce. And if you don't, it sounds like the direction of travel in terms of the legislation is going to just make that more difficult.
Yeah, there's been some amendments proposed to try and make it a right for an employee a worker, to request those guaranteed hours. So at least then the onus is on the worker to, if they want the guaranteed hours, they have to ask for them. Those have all been rejected. So now it's going to be a positive duty for the employer to just provide those guaranteed hours and provide that contract. Obviously, the worker doesn't have to sign it, but it's going to potentially create an administrative burden for employers. So if you can get ahead of it and do the review and make sure that the contracts are matching what's actually in place.
Yeah, and that's all we can say. And I think that that's the direction of travel, and that's the sort of mischief that they're trying to solve. Really, is that that when somebody's been there for a long time, and we're calling it a 0-hour contract, but it's not really. That probably needs to be looked at, and you probably do need to be, you're ready to sort of get serious with that employee and to have proper sort of mutual obligations and rights with one another at that point. It's difficult to find good staff, so perhaps that review is needed. Okay, so we're going to get Rob up in a second to give us a bit of an update on the recruitment and employment market generally, but just wanted to throw it open. Has anyone got any questions about anything that we've said today, or employment law generally, that that I could ask, that we could answer? Sorry, I'm not going to ask them. I've been doing the ask questioning and answering today. Yes. So, when you go to the dentist and they always say you should floss, and then you floss for about 2 weeks after you go to the dentist, it's a bit like that insofar as we would always say, there's my badge, never mind. We would always say that we should sort of constantly be, probably every 12 months or so, be reviewing your contracts generally. In terms of the change here, that I would make, if it's not in there, I would definitely have a clear probationary period, ability to extend that probationary period, and I would be having that in your contract now. Most people, because of sort of the changes over the last 10 years, have got and you're obliged to have a written disciplinary and grievance procedure, but it might be time to have a look at that. And then maybe there is, dependent on the size of your organisation, just a little bit of training for some of the managers who might be implementing decisions and processes around termination of employment. I think that, again, light touch is probably all that is required, not a particularly complicated process, but the fact that we're always going to tell the employee that they're going to a meeting where they might lose their job, that's important. That we're that there's notes, that the decisions are set out in writing, and that they get the right of appeal. I know I'm repeating myself there, but I think it's so important. And provided you do that, I think you eliminate, yes, in the future, a claim for unfair dismissal on day one rights, but also any of those whistleblowing claims or discrimination claims, you can virtually eliminate the chance of any of those succeeding against you if you implement the process and procedures. But in terms of the contract, have a look at that probationary period and see if it's in there. And it doesn't matter if it's 12 weeks or 6 months or 9 months, actually, or 12 months. Any of those things are fine, but you should have one in there. It needs to match what you do. And then, like anything, it's not just about what's written down. You've got to implement it as well. I mean, I think that it's always going to depend, I would say, on the seniority of the employee that you're hiring. Of course, references are important. I think that sometimes employees don't always ask for the references. They ask them, but then they don't necessarily. They're busy and they don't go through that process. Dependent on the nature of work that you're doing, you can do DBS checks. You can verify their people's identity relatively straightforwardly. I think that all of those measures are sensible. I personally have found when we hire, we're very positive about hiring young people in the communities around which our offices are located. We always do like to sort of kick the tyres, because once somebody's, say, a trainee solicitor, it's quite a regimented process. You're sort of locked in to that individual for for 2 years. So we would, yes, interview, yes, take references, but also have that sort of, and I don't want it to sound too much like a commodity, but that try before you buy period. We will often have people doing a little bit of work experience. That isn't the abusive sort of unpaid internship, but seeing them sort of doing the job, I think, is always a sensible thing to do. Asking sort of technical questions around the performance of the job itself is always something that I think is sensible.
That's also the purpose of the probation period. So as long as you've got that in there as well, once they're in, if it's not working out, at least you've got that process. As long as you've got it in the contract and the policies to go around that, you've got that process to help you with that.
So the answer to that is yes. We think that that actually not passing a probation is going to become one of the fair reasons for dismissal, almost on a sort of no fault basis, that you don't need to hang it on performance or capability or whatever. You can just say it's not working out in this. You've almost got a bit of a get out of jail card. Again, we don't know that for certain, but the real reason when I talk about, and I seem to have used the word probation, like I said that about 1,800 times today, but I think that what I really mean by that is it's forcing you to have something of a process. And again, unfair dismissal, there's the other bit of the badge. Unfair dismissal is all about is all about trying to make sure that employers follow a fair procedure, and that probationary period is actually the procedure that I'm sort of wanting our clients to follow to protect themselves, and they can start doing that now, and should start doing that now. The agency is the, I'm going to say use the word employer, but it's not that's not the language. What is the language? Is it engager? Looking at Julie, but the onus is on the agents in terms of the compliance, really, with the law currently. But of course, they're going to be, your contract with the agency will determine, they're ultimately going to make you pay for it, I would think.
Yeah. And what's been suggested is if the contract with the agency company specifies a number of hours, if you're then providing additional hours to that agency worker over and above that contract, then you're at risk of falling into this trap. They are going to look at excluding certain agency workers and regulating that more specifically. So it's going to be a watch this space, but generally it's on the
It is on the agency. I mean, they had all of that legislation following what happened at sort of Morecambe Bay years ago around the sort of, it sounds almost sort of ancient terminology, but the sort of gangmaster licenses and everything else, which were all imposed on the employment businesses as opposed to the end user, for want of a better word. There isn't, and I hope they don't legislate on that sort of thing. I mean, clearly, I suspect that most employers would know when that starts to move into an exploitative situation. I mean, really, the work, when somebody's doing work experience, it's got to be a two-way street in terms of the experience that you're giving them to experience the workplace. But if all of a sudden you're, I was speaking to somebody this morning who's doing some work experience doing sports journalism, clearly, going along to the football match, getting to know sort of how it operates in the press room and everything else like that. Clearly massive benefit for that individual to be having that experience. However, if that became every Saturday and he's now on their podcast and he's filming all of their content every week, there does come a point in which they need to start paying that person, and the national minimum wage legislation would kick in. I probably am more saying that, and we've have sort of vacation placements and have people in for a week or so. We've done that in the past, and it sort of seems to be quite a good system. And we then make a decision as to whether we want to give them a job, and then they will come and join us on a trial period, but we will pay them for that, and then we will pay the national minimum wage at least at that stage. Right, if I had the answer to that, I'd be really so I've been doing this for about 25 years, and in the early state, I used to do the CPD courses, and some of them were quite well marketed. And I must have gone on 3 of them on dealing with sort of long-term employees with long-term sick. Almost certainly they will be considered disabled if they're long-term sick, because definition of disability is ability to carry out day-to-day activities, and one of those is going to be is going to be going to work. So if they can't do that, almost by the nature they are disabled. The there is a common law concept of frustration of contract, and there is a point at which the contract will be, just by effluxion of time, will need to be terminated. The law would accept that. However, that runs contrary to the positive duty to take reasonable steps to in effect help somebody with a disability. Ultimately, all that you can do is work with occupational health and involve occupational health to see if it can be determined whether this person can return to work or not. In terms of performance management, it's difficult, and you're going to have to be really careful that what you're not doing could be classified as being discriminatory because of that positive. And I forgot the phrase reasonable adjustments was what I was searching for there, but because you've got that positive obligation to make the reasonable adjustments. We look out the room. I've dealt with lots of you guys over the years where that's been just such a difficult situation for employers, particularly the weird thing whereby you still get holiday pay, don't you, on long-term sick, and sometimes employed for years and you're still paying sort of 5.2 weeks of pay every year. Ultimately, I'm afraid to say that what often happens is you have to have that without prejudice discussion with them and do a deal which will stick in the craw and end up in a settlement agreement. I wish I could come up with some better ways of answering that question, but I can't. I don't. It's difficult.
Could I just ask on that subject?
Yes, that would be if you've. I mean, I think the onus, the lens or the telescope through which it's looked at is this obligation to make reasonable adjustments, and actually as an employer, when somebody has got a disability, you should be looking at through how can I help this person get back into work and perform their job effectively. However, and the process that you go with will almost certainly involve occupational health or medical advice generally. When you go through that process, if the culmination of that process is that the person just cannot return to work, and again, it's not sometimes is there a different job they could do within the organisation? But if the conclusion is they can't do anything within the organisation, then almost certainly at that point the contract would have been deemed to be frustrated, and that can be a fair reason for dismissal. And provided you've can demonstrate that you've acted reasonably and have looked at it with through that sort of telescope then and dealt with them kindly, I'd be surprised in those circumstances where you've got that report that it would be a fair dismissal and there wouldn't be a discrimination claim.
Yeah, it all comes back to having the policy or an ill health capability procedure in place, and you follow that procedure. If, as Martin said, if the culmination of that is that there aren't any adjustments that you can do to allow them to come back to work, then it would be potentially fair.
Invariably, this will be sort of a mental health. A lot of the time, we've got a mental health issue with the long-term employee, sort of depression. A lot of the time, the medical advice won't ever be the person can't. It will be they'll need more time and support. So you often sort of never get to that, unfortunately, or fortunately, because I do think sometimes when somebody's been through a difficult time and they are struggling in that regard, that a little bit like what I was saying about the employment tribunals earlier, that actually the kindest thing to that person can be to say, look, it's just not going to work out. Well, one of the things that sort of immediately comes into place is sort of the working time regulations. So, potentially an employee, if you're getting employees to do overtime, you're going to remind me of what the number of hours is. Is it
48 hours.
48 hours
per week.
Over a what average period? Is it 90 days or something like that? So you do, provided it's below that, then that is okay. You've obviously got to be paying them, got to comply with the national minimum wage. Your contracts of employment will determine whether you can force them to do that overtime or not. As to whether, if they refuse, can you take action against them if they don't? So I guess there's a contractual point there. But yeah, that's. I don't think
Depends.
where that is going precisely. However, you could see how that could be used by potentially that the legislation could go down that route. I mean, for example, where that would kick in is in relation to holiday pay. So as it stands, if you're working out when somebody goes on holiday, they should be paid their normal wage, which should include overtime. And going back about 12 weeks, I believe the period is, or is it 6 months? Ask us and we'll determine that later. But so there is an element of that sort of applies already in the context of holiday pay.
And also, it depends on what they decide the minimum number of hours is for these contracts.
They could certainly see that for like a part-time work. You could see how.
So a part-time worker, if they're actually working almost.
Again,
I
think that the rule to loads of this stuff is that if it walks like a duck, quacks like a duck, it's a duck. And that if you have got somebody who has for 6 months, 6 years, always been, working in the summer, they work 10-hour days, probably gets to the point whereby you do want to contractualise that, I would think, and it's in both of your interests to do that, to have that discussion with your employer. Now, that is an exam question. Sorry, what do you mean in terms of... Yeah. I mean, in terms of the 0-hour contract stuff, it won't, it won't apply to them. But although farms do use 0-hour contracts, I'm aware that in terms of some of the time around harvest time in particular, workers who come in and literally, work all sorts of hours for the month of September and then will ease off. Real answer is that I don't know, but actually, we don't say, I don't know. We don't know yet because we haven't got the legislation. But again, I don't think, coming back to the theme of today, is that if that's the reality of agricultural work and what you do matches what it says on the tin, and your contracts have got annualised hours, and it means that in the summer you begin working really long hours, and actually perhaps in January and February time you'll almost have got those months you're virtually not going in at all. All employers should try and make sure that what is written down is what they actually implement on the ground. And I think if you do that all the way through everything we've talked about today, I don't think you go too far wrong. However, I do get it that, for owner managed businesses in particular, it's the sort of thing that, that you want to implement, but finding the time to actually sit down and do that is slightly more tricky to happen in reality. Okay, so Rob Lawton from Greenwell Gleeson is going to come up and say a few words. Can I have your chair, Victoria?
Before I give an update on the employment market, a couple of observations and a question for you, if I may.
Okay.
I first became aware about the Employment Rights Bill just over a year ago, and saw the potential impact it could have. And it's frustrating, I think, for all of us here that we're still a year on, and we still haven't got definitive rules and laws for us to be able to make decisions on. So the expectation is it's going to be early spring, is it, when we get...
I think that we would almost certainly, I mean, Victoria's saying that there might be a limitation issue. Expanding the limitation from 3 to 6 months might come as soon as the legislation is passed. That might immediately get a sense. So you could have that as early as January, probably, which, extending the limitation period, which will expand the number of claims.
Okay, because I mean,
everything else will be, most of the other stuff, the unfair dismissal rights and the zero contract stuff, we think we're a good 18 months to 2 years away from.
Because when I learnt about it, or first started to read about it, I saw the implications it has on employment. And as a recruiter, we're looking to go beyond just our day job of finding jobs, but helping our clients with employment matters. And the two things, and we've run a series of these, and I think what's clear is probably when we do get clarity, that's when the specific questions that have been asked, you and other lawyers will be able to give answers. My takeaway from listening to yourselves and other ones that we've organised is the two
less good ones. Yeah.
2 P's, process and probation.
I should have come up with that, really. Yes, process and probation is a good little summary. Yeah.
Okay. So, and here's the question. It's occurred to me over the last couple of weeks that perhaps we've got a couple of competing forces colliding in terms of, we've got the Employment Rights Bill coming in and all of the talk about technology and for the first time impacting on white collar workers. In terms of making redundancies, letting people go, you may not be able to answer it. Is it easier, harder, or no difference between making blue collar people redundant generally, potentially if our clients, people here are going to have to, and some of my team are here, by the way, so I'm not asking for Greenwell Gleeson for myself, but is there a difference between and difficulty in terms of making blue collar and white collar people redundant?
There will be, just the nature of redundancy law. A blue collar worker may show up to work in a factory every day, right? And I think my clients who manufacture car parts and what have you, they go into a specific place. They've got one place of work. It might well often be all or nothing. If you're closing that factory down, they're going to be made redundant. Whereas actually for white collar workers, a lot of the time their contracts are more flexible. Yeah. So when you are deciding to identify redundancies in that sector, you need to make sure that it is a job that is being made redundant and not a specific, using it as a way of getting rid of a specific person. So I think that it can be more complicated, perhaps, and I don't want to sort of get into any sort of tropes about whether sort of information workers, white collar workers, are more likely to be Googling and ChatGPT and what they should be asking. We're definitely seeing a lot of that, but I suspect in this day and age, whether they're blue collar or white collar, they're going to be sort of fighting their case. I would say that redundancies, for the most part, are very difficult emotionally to do, but in terms of the process, tribunals won't want to second guess a reason to reduce headcount and will give employers a lot of leeway, provided you follow something of a process, one of your 2 Ps, that you're using objective criteria. You should be able to fairly dismiss someone for reasons of redundancy, for sure. Just let me know which of the ones you want to go, and I can give you some advice to help shape that objective criteria.
Thank you. I don't know where to look now. Okay. So thank you very much to yourself. Tony over at Lloyd's as well. I think you've played a part in terms of arranging today. But
thank you, Tony.
Gives myself an opportunity just to give you an update on the employment market. Maybe just a little bit what Greenwell Gleeson is doing in response to that. The UK employment market at the moment is exceptionally challenging. And whilst we specialise in accountancy and finance, which tends to be an inelastic, because we're not sector specific, we deal with any sector, we're seeing that as well. And pretty much every data point that I've been looking at reviewing draws of conclusion of a tough environment. Just a couple I'd highlight to you all. One is the share prices of a number of the large international recruiters, Michael Page, Robert Half, Hayes. They have all gone down by over 50% in the last 18 months, which highlights that it's not just a UK thing that we're going through. It's not just from our perspective in accountancy. These agencies operate over multiple different disciplines, over different countries. So for those share prices of those companies to go down by that much tells you there's something going on much broader in not just UK economy, but elsewhere. About 2 months ago, I was listening to the business news and heard the expression for the first time that to describe the American economy as a no hire, no fire, whereas companies were holding on to their staff, not looking to reduce numbers, maybe because they had been scarred by the difficulty in recruiting people post COVID. In the last month, they've changed that to no hire, more fire. And in October, and I talk about America, and obviously we're here in the UK, but I look at that as being a leader for where perhaps the UK will follow. America in October announced the most number of redundancies it has since the pandemic. As I was coming here over to Little Aston Golf Club, a year ago, the unemployment rate was at 4.2%. It was 4.8 as of last month when I made these notes. Today, for the first time, they've announced that employment's gone to 5%. So what we're seeing is, and I think the UK is reflective of that, employers have been holding on to staff, because of the issues they've had in hiring in the past, but now are starting to make redundancies. A couple of other data points. One, there's a great survey that comes out each month from KPMG and the Rec Association, and it surveys 400 recruitment firms, so gives over the whole country, over multidiscipline, and it's 18 months on the trot. The numbers have been coming down in terms of activity. They're suggesting that starting salaries have now stagnated, and the amount of people becoming available is increasing now, as by the 5% as redundancies kick in. I think more anecdotally, what we follow in terms of job boards, and with a couple of notable exceptions, pretty much all of our conversations have with the professionals we'll deal with it's taking longer to find work. There's people, the number of opportunities out there is diminished. What I will say is, over the last month, we feel it's stabilised. Things are not getting any worse. It is from a very low base, but things have stabilised. And when I was chatting to my team about this and other people, how I've feel the market is, it feels like 2010 to me. Now, 2008 and 9 were very different. That was when we were in the maelstrom of the crisis. We'd come out of it by 2010, but what we saw was companies, many companies, both large and small, acting with a similar mindset. It was a case of they were still nervous, so because they were acting in a similar mindset, the market was particularly slow, and that is what we are. There are significant number of fast-growing companies. There's some great examples of businesses growing at the moment, but generally speaking, companies, both large and small, are acting with a very similar mindset and very conservative. And what we're seeing is when clients do recruit, they're tending to be very selective on when they hire and who they hire. It's a case of, at the moment, really when you need to. So it is a depressed outlook currently in the UK market. The factors for that, I think most of them are pretty obvious. I think I'd just highlight two. One is we've been in what we call a client-led market since the pandemic, or close, where there's a shortage of supply. Clients weren't necessarily in control because there was a fight for talent. That has now flipped. In terms of, I think, from our conversation, employees are more nervous about their job prospects. We're all hearing about technology and how it's going to revolutionise. So employees are reading this, so they're more nervous. I think the changes to employ national insurance and whatever, I think it brought into employees as well, realise it costs more to employ them. So there is nervousness from the candidate side, so they're not looking to move, which slows the market down. And I think the other one is employers. You know, we talk about AI, and I think it's more broader technology. They're hearing how it's going to change the workplace. So if there's a perception that in maybe 12, 18 months' time, something's going to come along that means they need less people, or they may need to redeploy people in different areas, why would recruiters or employers potentially hire? They're just going to hold off. So that is, two factors outside of, say, what we probably all would recognise as that's driving that. It gives me the opportunity just to briefly talk about our response to it as Greenwell Gleeson and a recruiter. We've been in tough markets. I mean, we've been going, 34, 35 years. So we've seen quite a few different ups and downs. And, being a small company means that you're able to respond that much more flexibly than the larger corporates. And, our focus, chatting as a team, we're focusing on 4 key areas where we see as being, will help us weather it and drive our performance going forward. So we do accountancy recruitment, so we place finance directors, CFOs, both permanent and interim, all the way down. The first one we're focusing on is finance execs and controllers who can demonstrably pay for themselves. Clients are very cost conscious at the moment. People, are keeping things tight. So when they do want to recruit, we see as being essential finding talent that can demonstrate that they can pay for themselves, or more than pay for themselves, in terms of margin improvements, in terms of cash, in terms of exits, in terms of refi. So finding finance professionals who will more than pay for themselves, we see as being very apt for this market. The second one is finance execs with proven technology skills. Again, it ties into where we see technology advance coming in and companies adopting more and more technology. Finance execs, while not the IT and technical, they play an integral part in ensuring that IT is implemented correctly. First and foremost, with the cost-benefit analysis, is it going to pay for itself? Secondly, as I read the other day, you've got to have the right processes and systems, because if you haven't, all AI and technology will do is make the same mistake but quicker. So, finance professionals ensure that proper process systems can be put in place to implement the new technology. I say, and the finance person, in where there is an IT director, normally one of the strongest relationships is with the CFO and the CIO. So we see finance directors, and particularly also controllers, and even lower down, people who are technologically minded to help future-proof businesses going forward over the next couple of years. The third one is temporary staffing. I say with the uncertainty at the moment, we can see that clients may continue to delay hiring and making permanent decisions. So, that we're focused on ensuring we have good, talented interim people, because finance functions still need to turn the handle and process the data. So there's a focus on the interim. And the fourth one is part-time fractional, both permanent and interim. And I can give you a couple of examples just in the month of October, where we've worked with our clients to offer cost-effective practical solutions. If I use an example of a business round here, turning over around 30 million, the finance director, he or she will be typically on about 120k base. You add on bonus, pension, car allowance, and the employment costs, and you probably
just give me these people's details, please.
Okay. So it's probably all in cost about 180 to employ that person, and where we see a potential for, in some instances, how many hours in a working week does that finance director do, he or she, 180k level of activity. So we can see that as being an option, and working within that, upgrading the financial controller, so you get someone turning the handle and producing on a full-time basis or stuff, and then a part-time FD. And also we've had, with technology already coming in, we've had a couple of instances, say in October, where the client has started from a point of, well, I need a permanent FC, and we've actually on both occasions put a part-time one in. One, we suggested they up-spec it and get a better person between FC and an FD, and the second one where we just said it won't take that much time, and so we're able to offer solutions to our client. And I think the final point just that came out of this, and from a recruiter's perspective, the cost of getting it wrong going forward, and the issue and the complications potentially of getting a bad hire, the ERB will amplify that.
Yeah.
And therefore, from a recruitment perspective, we hopefully can be in a position where, with our processes and our expertise, to find the best.
Because you guys are an expert at doing that due diligence, presumably on those candidates, right?
Well, it's just something my team will listen to, and hopefully when they will listen to yourself, and you talk about the probation period, and you talked about referencing people and going that extra mile to try and ensure the best hire possible, so you don't have that. And that's where I see the value add for someone, like Greenwell Gleeson, saying, adding that.
Well, that's your specialism, isn't it? Right? Is in the recruitment and getting to know the people and kicking the ties, which I think is important. Well, Rob, thank you for that. I'm pleased that ended a little bit more positively than it started, because I was thinking to myself, you were talking about CFOs and CIOs, and I was thinking no one's going to appoint you as the chief optimism officer.
Well, if I could just come back with that, because I sat round with my guys at the beginning of October, and we went round the table and we said, how's your market? How's your market? How your market? And it's various different. You can imagine that, what it was. And I said, okay, well, that is what it is. And, when engaging with our stakeholders, tell it as it is, but every conversation it's got to have a but in it. People don't want to have negative conversations. So that's when we sat down as a team and said, okay, if that's what it is, let's be clear on what we believe.
I'm teasing. I came up with that CAO joke about halfway through your discussion there, and I was just thinking, how do I
keep the PP?
How do I deploy? I'm going to definitely keep the PP. How do I deploy that? So thank you for that. Well, guys, just to say, firstly, thank you, everybody who's come along today. Thank you, Martin, for organising. Thanks to the team at Urban Flux who've done all the audio-visual stuff. This will go up on YouTube and LinkedIn later on today, so you can watch it back if you found something useful. You'll be able to look it up for references purposes. So Urban Flux have been fantastic and are doing all of our sort of content currently. So if you look at on our YouTube channel, TikTok, etc., just watch it for more than half a second, please. Though, get those stats up, hit that like and subscribe button. So no, thank you for Urban Flux. Thank you to Victoria for standing in and becoming, I thought, an excellent interviewer at the last minute. And cheers for coming, guys. Thank you.